right, let's give it a second to get going here. All right, looks like we got a couple of people jumping in here. First, bitches, buddy, for real, bro. First, bitches, I ain't mad at you, bro. I ain't mad at you, but I think Just Blaze had you beat. I think Just Blaze had you beat. When you guys come in, number one, hit a like for the YouTube and Facebook algorithms for both me and my boy, and let me know where you guys are coming in from. I'm in Los Angeles. Saban is in New York. And what we're doing right now is we're doing another live today. This time, it is with a true bar licensed FCRA attorney in New York, Subhan Tariq. But we not on my Let me know where y'all coming in from. Hit a like for the YouTube and Facebook algorithms, no matter where you're coming from. What we're gonna do today is something a little bit different. I got an attorney here today to help me bust some of these damn consumer law myths, because this shit is getting really, really popular across all social media platforms, where you're seeing videos pop up now about consumer law this and consumer law that in regards to trying to remove information from your credit reports. I ain't doing that shit. What I do is I go straight to the source. Me and my boy Mike have built an amazing relationship with Saban. Like I said, he's a bar licensed FCRA attorney based in New York. He has recovered hundreds of thousands of dollars in punitive damages by suing the credit bureaus, creditors, and collectors for doing felonious things on your credit report, reporting things inaccurately, unfairly, and completely, collecting money in a way that is not in line with the FDCPA, and having reporting tactics that are not in line with the FCRA. You guys are going to get a great deal of information out of Saban. What we're actually going to do is we're going to go through some of these videos together. And he's going to give you his opinion as an FCRA attorney. I'm going to give you my opinion as a credit repair specialist. If my opinion is valid at this point, I may even find out that I'm wrong about some things that I think are going on. So I am open to the possibility of even being corrected here. So I hope you guys enjoy this. And like I said, let me know where you guys are coming from when you guys get into the lobby. And please, so that this can get out to all of my hundreds of thousands of followers, hit a like for the YouTube and Facebook algorithm. First and foremost, I want to go ahead and introduce you, Saban. This is Subhan Tariq of Tariq Law PC, based in New York, FCRA bar licensed attorney, and legal credit knowledge extraordinaire. Saban, what's up, man?
How's it going, Mike? Sorry, not Mike. Jay. Sorry.
You just did this with Mike.
I've had a long day. We've been doing. I've done some lives with Mike. Doing good, doing well. New York City has been raining for the past few days, and I'm looking forward to the sun finally coming out tomorrow. But it's raining here still now in Midtown, and so happy to be here. Happy to share some knowledge with you guys.
Yeah, man, that's pretty cool, man. I appreciate you giving us some of your extremely valuable and expensive time. So thank you for that, man. My people need it, man. My people need it. So what I want to do, first and foremost, I'll be going to Saban's Consumer Law Summit, which is early November, because I need to get more of this information for myself. This is going to be a 3-day in-depth training where he's going to basically give up all the sauce when it comes to consumer law, disputing, and anything else that goes along with dealing with the creditors, collectors, and credit bureaus from a legal standpoint, so we can stop wasting you guys' money, man. As many of you know, I quit normal traditional credit repair sometime in August. I put out a YouTube video. It got thousands of views, letting you guys know that I'm not doing this shit no more. I'm just not doing it. The way that we are doing credit repair in the normal sense is just not working anymore. And the reason is because the bureaus know, the creditors know, the collectors know that you can't sue them. They know that you have no real recourse. So they decided to stop playing the game for the most part. So if they take their ball and go home, what are we going to do? Well, instead of doing like everybody else does and continue to charge you guys for the same thing over and over and over and over again, I decided to go partner with some of the most knowledgeable people in the game and get the real information so that I can do what's right by you guys, the consumers, my followers, my subscribers. You guys trust me. And I want to make sure that I do everything in my power to bring you guys the most top-notch service that I possibly can. So I appreciate you guys coming in. We got Texas in the building, LA in the building, Cleveland. I'll be out in Cleveland early in February in the Brattonall area. Las Vegas, we got New Orleans, North Carolina, the Bay Area, Florida, Michigan. We got people from all over the country. I appreciate you guys, man. Make sure you guys hit a like for the YouTube and Facebook algorithms. Subhan, do you have anything that you want to say in regards to your practice and how things have been going for you when it comes to credit repair?
Yeah, so things have been good. As Jay mentioned, we have a Consumer Law Summit coming up at the beginning of November. That's consumerlawsummit.com. It's a pretty easy domain to remember, consumerlawsummit.com. And things have been well. We do mostly credit reporting. About 80% of my practice is credit reporting cases. About 15% is debt collection, defense, FDCPA stuff. And then about 5% of my cases are others like the Electronic Funds Transfer Act, is where your like bank account gets hacked and all of your money gets stolen, or the Equal Credit Opportunity Act, or other various consumer laws, state and federal. And I'm licensed here in New York, New Jersey, the District of Connecticut, the Federal District Court in Connecticut, and the Federal District Court in the Northern District of Texas. That's in Dallas. That's where Experian is located. So we can sue Experian in Dallas for any case across the country. Also admitted in the Second and Third Circuit Courts of Appeal, and I've had a couple of appeals cases. And I know that you mentioned earlier about recovering hundreds of thousands of dollars. At this point, thankfully, it's in the millions of dollars, recovering millions of dollars on behalf of consumers, and have gotten more than $10 million, actually tens of millions of dollars, eliminated in debt on as part of the process. So we've done pretty well. We're here located in Midtown Manhattan. I'm in New York City, just footsteps from Grand Central Station. At 99 Park Avenue. So if anyone's ever in town and you need a clean bathroom to go to Midtown Manhattan, it's a good place to come.
Yeah, I'm world traveled, man. I've been all over the world, but I've never been in New York, Subhan. I've never been.
That is, yeah, it's shocking actually.
It's weird, man. When I get on a plane, man, I'm changing languages, bro. I'm out of here.
New York is a great place. Unfortunately, it's had a bad rep recently with all the crazy stuff that's happening in our country. But
yeah.
New York is still the safest big city to be in America. It's one of the best places in the world. I've traveled a lot around the world as well, and there's few things that I love as much as coming back home to New York, drinking some clean water here, and grabbing a slice of pizza from my local pizza place. So
you sound just like a New Yorker, dude. You sound just like a
New York. New York's all about the water, the pizza, the bagels, the cheesecake. So New York has great food, and I know you're coming up in a couple of weeks left now. So looking forward to seeing you when you get here.
Yeah, man. Yeah, man. Like I said, man, I appreciate your time again, dude. If you guys come and you're new into the stream, tell me where you're coming in from. Hit a like for the YouTube and Facebook algorithm for both me and my boy Subhan. We're gonna get into it right away, man. I don't want to waste any more time. I want to jump right into this because I want to watch some of these videos that I know that many of you in the chat have had an opportunity to watch. And if you haven't, you've heard something like these videos before, telling you what you can do when it comes to consumer law representation or consumer law disputing of the items on your credit file. So let's get right into it. I got one pulled up right here. We're just going to go kind of in and out of YouTube here for a little bit. Subhan, you're going to look at it. You're going to tell me what you think. If you want me to stop at some point, man, tell me to stop and I'll stop it and let you kind of get your points off. Okay.
Sure.
So let me open this screen up here a little bit. Share my screen. All right, let's get it going. And if you guys have any trouble hearing this on your side, let me know so I can do something to fix it.
I don't hear it on my end. I can't hear it on my end.
What'd you say?
I can't hear it on my end.
You can't hear it at all?
No, I can't hear it at all.
Let me see here. Can you guys hear the video in the chat? Having trouble hearing.
No
Ooh,
audio.
no audio. Okay, hold on. Let's see. Let's see. Hold up. Hold up. Hold up. 1 second. Let me see what's going on. Desktop audio says it's coming through. Hmm. Give me 1 second, you guys. Let me see if I can't figure this out. Oh, I know why. Okay, hold on. I think the audio is going. Of course, my bug guy shows up as soon as I start the stream. Hang on. Can we, oh, all right, Mike. See, I don't show up on your stream, bro, messing you up. Hold on. Let me see here. That's funny, though. I do not know how to do that. Let me see if this fixes it. Oh, no, it is this one. Let me move this out the way. All right, let's see if you guys can hear it now.
No.
Is it going at all?
No, I can't hear it.
Oh, bro. This is no bueno.
I think we were having this issue with Mike a few times ago. I think you have to take the video down from the studio and then re-add it to the studio, and then it'll play. It's like a timeout issue.
Okay. Okay, so I'll tell you what. Let's just have a conversation since we can't talk about we can't hear the video. Can you hear me right now? Hear me okay?
Yes, I can. I can hear you.
All right, let's have a conversation about this video, right? So he was talking about the USC. Did you see it?
No, I didn't see this video.
Did you see which USC code he was talking about?
Let's see how to delete anything from your credit reports. That's always a scary tactic. It's too pixelated. Can you zoom into this video a little bit?
on with it. Okay, so 15 USC
15 USC
1681
1681
I-5.
I-5. Okay, let's see.
What's up,
15
Cameron?
USC
I know you guys can hear
16
me,
I-5.
but for some reason you guys can't hear the
So
video.
there isn't a there is an IA5. There isn't an I5. And if I can add here,
Explain to us, bro, how this helps you remove absolutely anything from your credit report.
let's see. Let's see if can you see my screen? No.
No, I can't see your screen yet.
Um, what's that? Do I think you may have to? You may see it in the. So there is no I5. There's an IA5, but that's just the treatment of inaccurate or unverifiable information, which is if after a reinvestigation of any disputed information by a consumer, an item of the information is found to be inaccurate or incomplete or cannot be verified, the consumer reporting agencies shall promptly delete. There we go. Promptly delete an item of information from the file or consumer or modify that information as appropriate based on the information, based on the results of the reinvestigation, and promptly notify the furnisher of that information that the item has been modified or deleted. Uh, so, as I mentioned before, so this is 15 USC 1681. There isn't a direct I5. There's an IA, then down to 5AI, big A. So, and then if we scroll down, yeah, there's yeah. So, but this is just the normal dispute process. If you dispute an account that is uh, on your credit report, the credit reporting agencies have to perform a reinvestigation of the disputed information by the consumer, and they have to delete the information or modify it to update it to correct it as appropriate based on the results of the reinvestigation, and and they have to promptly notify the furnisher of that information. So I don't know what this person is claiming, but the first of all, his citation is wrong, and second of all, uh, I don't know the rest of the video and what he's claiming I says, but you have to show that the item is incomplete, inaccurate, or unverifiable in order for it to be. So it has to be inaccurate or incomplete or cannot be verified in order for the credit reporting agencies to update, modify, or delete the account on your credit report.
Can you hear me? I just duplicated my screen real quick. Can you hear me now?
I can still hear you.
Okay. Tell me if you can hear the video.
No,
You still can't hear it?
still can't hear it.
Jesus. Okay. Okay. So we'll get rid of that then. Okay.
I
So
think try to close out this window. Maybe copy the URL. Close out this window. Share. Take it down from the little bar that's down here in the studio bar, and then add it to the studio bar, and then maybe try to play it then.
okay.
Because that's what the issue that we were having with Mike.
Okay, Cameron said there's a video conflict using the same browser for streaming and playing a video. If streaming Chrome in Chrome, play video in Safari. Okay, so let me see if that would suffice here real quick. No.
All right, listen. We're gonna
There
talk
we
about
go. I can hear it
uh,
now.
try y'all. What?
My man, Cameron, my boy, my boy. See, that's why I love y'all, man. Y'all always keep me rocking. Okay, so in regards to this one, uh, and yes, Mike, I'm on StreamYard. In regards to this particular video, there is no way to utilize this particular section of the FCRA against the creditor, collector, or credit bureau to just remove anything from your credit report. Is this correct?
That is correct. You can't just delete anything.
Okay.
And this is where a lot of people are, a lot of false advertising out there when it comes
Okay.
to what is possible on the credit
Okay.
report.
Okay. So I had typed in consumer law credit repair. I want to see all the videos that belong to this. All right, so let's check out this one right here. Let's see what this is
And
about.
so let's just quickly go through this. And the reason why I want to show this is because a lot of people think that because someone gets a 1099-C, cancellation of debt, that they are a deadbeat. They are not a deadbeat. So specifically, let's just look at the companies here. We got Wells Fargo, $25 billion. State Street Corp, $2 billion. Bank of America, $15 billion. J.P. Morgan Chase, $25 billion. Citigroup, $25 billion. You see that? Billion. Morgan Stanley, $10 billion. Morgan Stanley and Chase, aren't they together? So we can make that $35 billion. Goldman Sachs, $10 billion. Bank of New York Mellon Corp, $3 billion. Let's see if we. Those are the ones that we.
Okay, I see what this dude is doing here. So he's trying to tell people don't feel bad for not paying the money back that you owe. Because if you get a 1099-C, the debt is forgiven. Go on about your business, start your life over anew. I don't think that's the way 1099-Cs work. I think 1099-Cs, at least as far as what I'm used to, 1099-C absolves the person who's trying to collect the debt of claiming that information as income on their future business taxes, and it makes you liable for that income as far as filing your taxes the next year. Is this correct?
That is correct. And I would say it does not completely extinguish the debt. There, there are, um, there is case law that merely sending a 1099 does not automatically discharge your debt. That uh, there are other steps that are required in order to get the discharge. And then there's a difference between a charge off, a discharge, and an actual discharge. And so, in the actual discharge, situation, the debt is eliminated, discharged, and then the 1099 merely memorializes the discharge, and so there's no debt owed. So there is a difference between that and just merely getting a 1099. That doesn't completely absolve the consumer of liability. It just creates this possibility that it's been discharged or eliminated, canceled, but it doesn't automatically cancel the debt. And actually, I get a lot of questions on this issue about 1099s. It's the best way to deal with that is to when you get the 1099 is to call the creditor and ask them if they intended on canceling it or if they were just doing it as a tax issue, and then they will tell you whether the account has been canceled and completely eliminated as a whole.
Does this something you need to get in writing? Is this something you need to get in writing? Say you call in, right? You said call in,
Yeah.
ask, hey, have you guys decided that this debt is canceled? Is it eliminated, forgiven altogether? Or are you guys just writing this off as, unable to collect? So this is something that they will provide for you in writing.
They may not. The call, if you record the call, that is enough. They also tell you all calls are monitored, recorded for quality assurance and training purposes. Um, we all as Americans have heard it so much that we've all memorized that term that all calls are monitored or recorded for quality assurance and training purpose. So I wouldn't, you can surely record a call if they're recording a call, and if they're telling you that calls can be recorded. It depends on your state. So if you get a collector on the phone or creditor on the phone, you should just tell them, "Hey, I'm recording this call for my records." But if they've told you that the debt has been canceled, then that should be enough to uh, continue to dispute it. And you could tell them that I've contacted the creditor, and the creditor has told me that the debt has been canceled.
Okay, cool. Let's get on to the next one. Look, this is the same cat coming back with another one.
All right, listen. Hopefully you're blessed. I'm blessed. I want to bless you with some information. So we're going to talk about the fact that these late payments are illegal. If you have late payments, there's good news. They are illegal. We're going to walk through a law that you can use to actually remove them. There's so many laws if you listen to my
Late
podcast,
payments are not illegal.
but we're going to talk about
What'd you say?
Late payments are not illegal.
I think hopefully we all know that by now, bro. Hopefully there is an ounce of common sense with people that would tell them if late payments were illegal, if they would have been abolished years ago. But
yeah, plus, the whole purpose of the credit reporting agency is to report, accurate, timely historical data. So if there was a late payment,
well, according to some of these gurus, just reporting information to your credit report at all without your permission is illegal.
that's kind of crazy.
Is there anywhere in the FCRA that you have found? Because I've gone through it a couple of times, but my memory doesn't stick like a legal professional. Is there anywhere in the FCRA that even intimates at all that reporting information to your credit profile is illegal without your consent?
No, absolutely not.
Now, when you apply for a credit card, an auto loan, a home loan, or anything like that, are you not giving consent through that application and the terms and conditions that come with that? That if the information will be reported to the credit bureaus.
Yeah, they're going to be performing an inquiry on your credit report. Also, something important to remember is that your credit reports, the credit report of the consumer, to the credit reporting agency, you, the consumer, are not the user of your report. You're not the person that's actually pulling your report. You are the product that the credit reporting agency is selling. Your information, your historical reporting data is what the credit reporting agencies are selling to credit grantors, the banks, the mortgage lenders, the car loan company, your tenant screening company, your landlord, your employer. You are the product. You are not the user of the credit report. The users of the credit reports are the people or the companies that are pulling your reports, that are doing the inquiries on your report. So you, the consumer, are the product of the credit reporting agency. It's your information that they are selling. Just like Facebook is free to use, you can choose not to have a Facebook account, but with the credit reporting agencies, you don't have a choice in this process. That's why the Fair Credit Reporting Act came out in the first place, because there was all this unverified, inaccurate information about consumers that was being reported by these companies, and Congress decided that, hey, they need to be regulated. And so that is when the credit reporting agencies became under the purview of the Fair Credit Reporting Act, is when Congress realized, hey, these companies are selling all this information about consumers, a lot of which is inaccurate. We need to give consumers the right to dispute it, and if they're not, if the credit reporting agencies are not correcting this information, then you can sue them. Consumers have the right to sue the credit reporting agencies.
Okay, that's cool, man. Good elaboration on that. Cameron had a question. The man who got this live stream out of the grave. I have a creditor who listed the debt as discharged and sold it to a third-party creditor who now calls me. That's double dipping for an original creditor. Charge off, then selling a debt to a third-party collectors. Your opinion?
That is not double dipping. If a creditor has charged off so there's a difference between charge off and a discharge. If an account has been charged off by the original creditor and it has been sold or transferred or is just being serviced by a third party debt collector, that in and of itself does not that's not double dipping. What would be double dipping, or what we call double reporting or dual reporting on a credit report, is if both the original creditor and the debt collector were both reporting a balance. So if one was reporting historical data but not a balance, and the second and the creditor and the debt collector was reporting the same account, um, but with a balance, then that's not double dipping. But if both of them are reporting a balance, then that is uh, dual reporting on a credit report.
So Cameron, I have a question. Cameron, would you mind camming up, Cameron? If I send you a link, would you mind camming up? Because I want to make sure that the way this is reporting is reporting with a balance from both the original creditor and the collector. This is where you run into the issues.
So that's correct. And also they're allowed to report historical data. So if an account was with an original creditor and stayed on, was with an original creditor until, let's say, May of 2023, and then it was transferred to a debt collector in June, then the original creditor can report all of the historical data up to the date that it was charged off. And then the third party debt collector could report an account once they received it, but they cannot report, the both entities cannot report a balance. So only one entity can report a balance.
All right, we're gonna get Cameron in here in just a second to kind of explain his situation, because a lot of people have this particular part of, I don't know if it's FCRA, FDCPA. I believe it's FDCPA, but might be both. You cannot you can report both as having original creditor charge off, collection company collection. You can have those both as long as charge off company has zero balance, collection company has the balance. So I want to make sure that Cameron is getting the right answer here, or is he trying to describe something else? Cameron, I put the link in the chat. Go ahead, click that, man, and you can come up when you're ready, dude, and we'll go ahead and have this discussion. Other than that, I'm gonna let this video finish, and then we will continue to discuss.
15 USC 6802. So look up 15 USC 6802. I'm going to read the section I want y'all to be aware of. 15 USC 6802, I want y'all to be aware of the B section, opt out. So it says, in general, a financial institution may not disclose non-public personal information to a non-affiliated third party unless there's A, B, and C. I'm just going to go through B. So B says the consumer is given an opportunity before the time that such information is initially disclosed to direct that such information not be disclosed to such third party. So let's go back. A financial institution, which is whoever has your late payment reporting, right?
I knew it was going to cut him off, but what are your thoughts on that particular section right there, as far as in regards to illegality of reporting late payments?
It's still not accurate. I mean, this section is not related to so all these so there's in every single statute, right? So let me show you here.
Okay. And then Cameron, after Subhan explains this, I'll get you up here. We got Cameron in the building.
Okay, so if you show my screen, you see each of these words, the reason why you can click on it is because it is a defined term. Okay. It's a these all terms. So, and then also 15, there's an entire section of the US code that's devoted towards credit reporting, the Fair Credit Reporting Act. This is exactly what they're about. So I would not and this is primarily meant for marketing purposes. This is not meant for credit reporting purposes. So I wouldn't give too much credence into what some random person on the internet who is a non-attorney is telling you about uh, a subsection of the U.S. code that he can't even sue for himself. There's a lot of people out there who will tell you all kinds of stuff.
Sure. But the thing
But
about this, Saban, is, and the reason why we're addressing this the way we're addressing it, and you guys hit a like for the YouTube and Facebook algorithm for your boy, so more people can see this live because we know how Facebook and YouTube be doing. But the reason why we're going over this the way we're going over this is because so many people get visibility of so many of these different videos. They don't have access to you, bro. I do. I can call you flat out and be like, Saban, I know what the deal is, but explain this to me. And you'll explain it to me and make it really easy for me, right? But how many of us have access to this? This is the reason why I'm trying to utilize my platform in the way I'm utilizing it. I know this is not a sexy live. I know it's not a sexy topic, but it's the realest as it can possibly get, because people like this dude will then put up his course or put up his credit repair program and swear to God that he's disputing using consumer law. When, like you said, he can't sue. You can't dispute using consumer law if you don't have the back end portion of it. So that's the reason why we do what we do. We got Cameron up here right now. Cameron, can you hear us? Can you hear us, bro?
Yes, I can hear you. Can you
Hey,
hear
man,
me?
thank you so much for helping your boy out, man. I was over here on a struggle bus, bro. So thank you so much for helping me get this show back on the road, man.
Yeah, no problem.
So what's your bro? Talk to us.
Hello. So the question that I was asking is that there's a creditor, and I'm saying this. I'm asking this question based on accounting principles. I'm not an accountant. So the original creditor has deemed the debt uncollectible and charged it off. There's a tax credit for that. Then they've resold the debt to a third party collection agency. So they got a tax credit for a debt, and the same debt they've sold at a discounted price to a third party collector. The only thing that they haven't done is issued me a 1099-C where I have to report it as an income. So that's why I was calling it double dipping on in regards to accounting principles.
So charge off means that you're right, that they deem it to be uncollectible. But they are not discharging the debt, or they are not canceling the debt. They are just deeming it that 6 months after you stop paying. So, that's on your credit report, you see 30, 60, 90, 120, 150, 180. And then after 180, you will see the CO of charged off, which means that they have deemed it to be uncollectible on their active collection books. So they are not deeming it to be canceled or discharged. They are just deeming it that that they don't expect that you will actively pay it. It's not an active collections account. It's been charged off. Now, what they will do is they will likely turn to a third-party collector and say, hey, if you're interested in purchasing this debt, you can. Remember, the debt still has not been paid, right? So the debt obligation. If you think about it as a fire, the debt obligation is still outstanding. And then what will happen is the debt collector will try to collect on the debt, and they have the full right to be able to collect on the debt. There's plenty of case law out there that says that a charged off account is still collectible. Even an account that the creditor may have issued a 1099 for is still technically collectible. It's only when there's been an actual discharge, an actual cancellation of the debt, that they have, fully canceled, that they fully extinguished the fire. So a debt that has been charged off by a furnisher or by a creditor is still fully collectible. by a third-party debt collector.
Now, with the same debt, I've heard that there is a process for transferring of a debt from one party to another that requires notification to the debtor.
You are not required to receive notification of that debt transfer. They can transfer that debt freely. There are some differences in the mortgage context. And I'm not going to talk about those right now. But but let's say it's a credit card debt. The credit card company does not need to provide notification if they are going to transfer that to a third party debt collector. They may send it to you. They may send you a notice if they choose to. It's also possible that the third party debt collector sends you a notice and lets you know that that there's a difference. But and then but in the mortgage context, there's a different reporting and transfer documents and all of that stuff. We're not going to talk about that in this context. We're going to be talking about like credit reporting just for like credit card debts or any sort of normal consumer debts. They do not have to provide you with notification. There is something called a forward flow agreement where and then there's like a chain of title that's generated that goes back to the original creditor of who has title to collect, especially if it's been transferred from multiple entities to each other. But that notification is not required to a consumer on a normal credit card debt.
All right, thank you. Thanks, Jay.
No problem. And one more thing before you go, Cameron. In order for him to, is it possible for him to request that they send him a 1099-C or a 1099 in order for him to try to force that situation? Is that what you're trying to do? You're trying to get that 1099, Cameron?
No, I'm not necessarily attempting to get the 1099. It's just that in the process of having a debt and is changing hands and payment is being made based on the amount of the debt, it's just my logical thinking that as in some part that they're paying the debt or some portion of the debt because they're buying the debt. It's just like on the street. If you owe me money and somebody else want to more or less have hold something over your head, they can buy the debt from you, and so then you no longer owe me, you owe the person. And the only difference between on the street and the government is that it's legal.
No, but the key element there is that you still owe the debt, right? So let's say Jay owed me $100 and he wasn't paying me, and then you came and said, "Hey, look, I know Jay owes you $100. I'll pay you $50 for the right to collect on that debt, and I'm gonna go to Jay and get all 100 from him." And I'm like, "All right, cool. I'm just happy that I get some money because Jay ain't paying me." So then you pay me $50. That doesn't mean Jay don't owe me. Jay doesn't owe the $100. Jay actually now just owes you the $100 instead of owing me the $100. So you got to think of it that way. That instead of the debt collector is just paying them. Yes, the debt collector is paying them pennies, but this is money that the consumer is not paying at all. And so the original creditor is just being like, "I'm happy to take some money because, Jay's not paying me."
I understand what you're saying, and so in that instance, as far as like on the street, I wouldn't pay the other person until I verified it with the first person, because some people are shysty like that.
So
without there being any verification.
Yeah, that's possible. That's where I was talking about a chain of title and an agreement in place, like a forward flow agreement, which is like, okay, you owe me, and then I owe him, and then et cetera, et cetera. But So I mean, what you're talking about is just verifying that there's a chain of title, that you have the title to collect on the debt. I mean, that's still possible. You can ask for that from the from the debt collector, and then there's possible that the debt collector may not have it, and that's a legal loophole that you may be able to use in order to not pay an account. But that is, it's not, it doesn't extinguish the debt.
And what happens if I apologize? May I, Jay?
Hey, go ahead, man. Go ahead.
Okay.
We got a question from Latanya Ransom coming up here.
Thanks.
I want to know if she want to jump on, so we'll get her on next if she wants to. Go ahead.
Okay. So in this instance, what happens? Oh man, what happens if? I apologize. I lost my train of thought.
If it comes back to you, man, feel free to jump back on, man.
Okay, we'll do. Thanks.
All right, cool. So we got another question up here from Latanya Ransom. I'm new to the live. I have a credit card, or I have a credit that reports a charge off. She might probably mean a credit card that reports a charge off each month. It reports a C to the bureau, so I get monthly messages that the creditor has updated the information. Is that legal, and how can I dispute that?
Yeah, so it is legal if it's being reported as a charge off, because that is the accurate, reporting of what the current account status is. It still may be possible to try to settle that account. So you may want to reach out to the creditor and try to settle this account with them, or it's possible that they've already transferred it to a third-party debt collector. But is that legal? Yes, it's illegal for them to report a charge off. And how can I dispute it? I don't do credit repair, so I can't answer that question. But you can dispute it if it's otherwise inaccurate, unverified, or incomplete.
So, Latanya, let me add a little bit from a credit repair perspective, right? So, when you're talking about the charge off reporting C month after month after month on your credit report, it's not reporting it as a new charge off. A lot of people mistake that as the charge off being reported as a new charge off every single month. It's not being charged off then brought back, then charged off then brought back. It's aging. It's aging out. But they do have the ability to continue to report that charge off as long as it is still reportable, and as long as it's not time barred by reporting standards. So that's all it is. It's not a new charge off every time you're being notified. It's the same charge off. It has the same initial charge off date. It's still going by the same initial first date of delinquency as far as aging out to be a time barred debt as far as reporting standards go, and even collecting standards go. So I wouldn't trip too much on that. It's the same charge off. So it's not being renewed. It's not being re-aged. It's not a brand new charge off. It's just being reported that way because most credit reporting software only reports 2 years of activity. They're allowed to report that charge off for 7 years. So as long as they are able to report that charge off, it needs to be valid on the credit report as it continues to move through the credit report and age out. So that's all that is. Okay, I hope that makes sense to you. We have another question from Angie. I heard once a creditor sells the debt to a collections company, once they reach out to the consumer can inquire that the collection company provide proof, i.e. signature and payment history.
So signature may not actually be required based on if the account was created online or whatever. But you do have the right to dispute an account, and you do have the right to request proof that they have the ownership or the right to collect an account. So all because a third party collector contacts you does not mean that they actually own the account or that they have the right to collect on it. And so you do have the right to request for that. New York City has a great debt collection guide. So if you go on Google and you just type in NYC debt collection guide, there's like a 20-page PDF that walks you through as a consumer, how to dispute an account, particularly with a third-party debt collector, and then how to try to get the right paperwork to prove that they have the the ownership or the right to collect on an account.
And what are they looking for exactly when it comes to the ownership or the right to collect on an account? Because there's so many different things out there that people say you can get back from a collections company, i.e., they have to send a wet signature. If, as
They
far as I
don't
know,
have
that is not
to.
the case.
They don't have to send a wet signature. They have to send enough documents to show that they have the right to collect on it and that the account is yours, and it's that they have, the charges that were made are also yours. Um, in New York, there's an account stated provision. So let's say you had a Capital One card or a Credit One or whatever company card you had. They can send proof that they have that the account was transferred to them and that this is the account that the charges were made on, and they can try to use that to collect on an account.
Okay. We have another question here from Dorothy. How I think she's meant how many years can they collect? Dorothy, this varies from state to state. Every state has their own statute of limitations as far as time bar debt goes for collecting on a debt. So it depends on what state you're in. And Saban, I heard something from another attorney, and I want to run it by you because I trust your information, more than anybody, pretty much. Uh, I heard that collection companies, or excuse me, creditors as well, can utilize any state that you've lived in order to collect on a debt. Is this true? Because I don't want to make a video on this because I could not find the 100% answer.
I will have to look into that and get back to you, but from it doesn't seem that way. That it would have to be uh, the the state that you opened the account or the state that you were living in at the time the charges were made. I mean, if there's a bunch of different states that you were living in and the states vary, um, you know, that could change the calculus here. And then also, um, deep down in the terms and conditions of the credit cards, each credit card company is a little different. So, like for instance, Chase, they all of their credit cards have a choice of law provision for Delaware. And in Delaware, the statute of limitations for a breach of contract is 3 years. So for all Chase credit cards, they would all be, no matter where the consumer is living, they would all be in Delaware, and the Delaware choice of law provision is a 3 year statute of limitation. So I would caution against kind of just thinking about it from the perspective of how many years and where they've lived. I would kind of look more towards where the defendants are located, or sorry, where the creditors are located. In this case, the defendants are
The
actually
defendants.
consumers.
You don't see so many of them.
Actually,
They're all just defendants to you.
to me, they're all just plain defendants. The creditors are at least. So, in this case, I would look at to where the creditors are located. Like Chase, for instance, is in Delaware. Bank of America is I think in North Carolina, or possibly I have to look into that. But so it depends on where they're located, and then if they do have a choice of law provision, and then also it depends on your state. So some states like New York previously had a shifting statute of limitations. So if New York previously the statute of limitations was 6 years, but if the creditor was located in another state that had a lower statute of limitations, then New York would take their statute of limitations. So it was a real kind of a mess.
Okay.
But New York recently changed it to 3 years for everybody. And so now the statute of limitations on to collect a debt in New York is 3 years, and New York actually changed it so that even if you make a payment, the statute of limitations does not restart. So, yeah, so that made it
Whoa,
much better for consumers.
that's a
And
hell of a
so,
precedent.
yeah, and so it is possible for
Okay.
it depends on where state and what creditor they are.
Good stuff. Hope that helps you, Dorothy. And Dorothy says she's in Ohio. So Ohio's statute of limitations for written debt, which would be like auto loans, I believe auto loans and other like personal loans and things like that. would be, I think it's 8 years, and then for like credit card debt, I believe it's like 6 years. So kind of depends. And then you have to take into consideration what Saban just said, because there could be other factors at play there. So
Yeah,
uh,
particularly if there's a choice of law provision, like for instance, a Chase account. Chase has a 3-year choice of law
right.
provision. Sorry, choice of law provision with Delaware, and Delaware is 3 years. So that's something to just keep in mind.
Okay, cool. So Cameron remembered his question, and Latanya, you're welcome. His question was, what does it mean if the contract with them is what does it mean if the contract with there is no disclosure that the creditor has the right to sell or transfer the debt? So I think what he's talking about is if in the contract there is no disclosure that shows that the creditor can find other ways to collect on the debt via collection efforts.
I can't speak to a hypothetical because I
Right.
don't know what the rest of the contract says, but generally speaking, creditors do have the right to transfer or sell a debt. It's just like the same example that we were using before. If Jay owes me $100, I realize that Jay's not paying me, and Cameron decides to, I'll give you $20 for the debt that Jay owes you. Uh, I have there's nothing limiting my rights to transfer that debt to Cameron, and then Cameron going and try to collect $100 from Jay.
Okay. And then a follow-up question. In over 2 years, I've asked for documentation of debt from the creditor and collections with specific details, and they have never provided proof. The credit bureau has simply responded that the debt has been verified.
So it depends on what the situation is there.
Well, if you request specific information, let's just forget everything else. If you request specific information, is the creditor, the credit bureau, is the collection company, are they obligated to send you exactly what you request?
No. So the way that the Fair Credit Reporting Act works is, and I don't want to just say no and then not qualify. So
It's fair.
no, but still under certain circumstances, yes. But um, it depends on your state if they're required to. Under the Federal Fair Credit Reporting Act, um, and this is for an original creditor, not a third-party debt collector. Okay, so if there's a third-party debt collector involved, there's a separate calculus if the FDCPA applies. But if you dispute an account with the credit reporting agencies about a particular creditor that's been reporting an account on your credit report, the creditor themselves have no obligation to send you anything directly. 1681 S2A, which is the subsection that deals with the responsibilities of furnishers of information uh, that that's not through a dispute, says that um, any direct dispute that you may send them, they are not technically obligated to respond to. Section 1681 S2B, which governs how the furnishers have to reinvestigate an account after they've received notice from the credit reporting agency, is only related to responding to the credit reporting agency. They do not, again, have to respond directly to the consumer. Um, if there is an FD, if there's a third-party debt collector, again, that can vary state to state based on your state laws. And if you have sent validation requests under 1692G, then that could change the calculus. But generally speaking, if there's just an original creditor and uh, if there's just an original creditor on the credit report, if you send them a dispute through the credit reporting agencies, they are not obligated to respond to you directly. They're obligated to respond to the credit reporting agencies, but not to the consumer directly about the dispute.
Okay, very good. Hopefully that answered you guys' question. We got another one from Angie here. What about late charges? Can they be removed? It's been said that the credit bureau has to validate the late charges with the creditor once the consumer disputes the late charge. You and I had a conversation about this not too long ago, Saban, about how late payments need to be verified. And I was under the impression, now this is something that I learned new from Saban, that I was under the impression that if you dispute a late payment in November of 2021, right? I thought that they had to prove that you were in fact actually late in November of 2021. Now, Saban, go ahead and give your opinion, not opinion, your
So
knowledge exactly how this works.
so technically, you're right in that they do have to prove that you were late in November 2020, but there still has to be a materiality aspect to the case.
Explain what
Uh,
materiality means, man.
so that means that you were not late at all. Okay, so if you dispute a late charge and you were late in October and it shows that you were late in November or in December and you were late in, whatever, but you were actually late. Okay, if you were actually late, then there isn't much that you're going to be able to do in terms of trying to sue to get it fixed. Now, there are issues about maximum possible accuracy, but you have to show that you were harmed by the reporting that you were late in November and not in October or September. So I would tell you that you have to be really careful about whether the consumer was actually late, when they were late, and whether or not something uh, has how it's impacted the consumer's credit reporting.
So in essence, if it ain't really hurting you, it's gonna be very, very difficult to go against go against that
Yeah, I
if
mean,
it's
unless
late fee level.
if you were actually late, that's the
Right,
key element.
right.
If it's saying that you were late, and you were late in September and not October, and it says October, it's hard to show damage based on that 1 month. But if you were never late and it's showing that you're late, then that's a huge impact, right? And you can more likely show that there were damages that stemmed from it.
Now, in the past, I have disputed specific late payments, and this is particularly previously to 2020, disputed late payments on people's credit file. And I've requested that either prove that this particular customer was late in this particular month or remove the late payment, mark the account as paid as agreed, never late. And it typically used to work. These days, that shit ain't working no more. So I'm trying to figure out exactly what stopped that from being effective. What stopped that particular process from being an effective process? Do you have any input on that, or am I just kind of shit out of luck?
Can you just repeat the process for me for a second?
So in the past, I would submit a particular letter, and I've given this letter away for free to probably tens of thousands of people at this particular point. A particular letter that would allow, or not allow, but it would request certain information from the credit bureaus, and if you cannot provide this information as far as the late payment being late at a specific month and year, then you have to then please update the account as paid as agreed, never late. It used to work like a charm. It is no longer working like a charm. It is barely working at all ever. So I'm trying to figure out what changed, or if they just decided to nut up and figure out, hey, you can't do shit about it, so we ain't gonna do shit about it either. But since COVID, this is just not rocking no more.
I think it's probably a combination of a few factors. One is probably they realize that they don't, they're they're getting 100,000, 200,000 disputes a day,
Right.
so they're realizing if I can't get sued for it, I don't need to waste my time. Number two is that a lot of these, a lot of the reporting is getting automated and verified and checked by, checked by computers. So it's possible that the furniture is just verifying the information using technology.
Yeah.
Um,
That's the way I've explained it to people. Is
yeah,
that look, we
that's
live in
probably the
2023,
case.
bro. This is
Yeah, That's probably the case where the creditors are actually able to, check whether an account was actually late. Um, and then there is the possibility that the creditor, I mean, the creditor's checking to see if whether or not it's actually true, and if it's true, then it's getting corrected. Or sorry, if it's not getting corrected, or sorry, not getting deleted. But it's possible that it's just true, and it just they're checking on that and updating it or verifying the account.
Right. Okay. Cool, man. Let's rock out with a couple more videos, man, and let's see if we can't
I see a good question here from
go ahead, run it.
Zio. I don't think I can click that, but it says I have a medical debt, a hold a hospital bill from 2007, and again, it's on my on my credit report. This collection. I think that could be potentially a good case for a re-aging of an account. You would have to pull your credit reports, and if you have any documentation about that hospital bill, and then if it's a third party debt collector, there could be additional remedies there. So I would try to pull your credit reports, and then you can send it to us, or you can send it to a consumer attorney near you who could.
I don't know how to pronounce your name, but if you want me to take a look at that for you, like within a week, text help me to 310-919-2002. I'll take a look at it, and then I'll send it over to the attorneys, or I'll send it to Subhan and let him kind of take a look at it and see what we can do.
Yeah.
No charge, no issue. But a lot of times people will say things like this, and there will, for some reason or some way somehow, been a reason for it to be re-aged. So like a lot of people will say, okay, it's an old hospital bill from 2007, but they were paying the bill, and then they stopped paying the bill sometime in 2017. You get what I'm saying? And then it didn't really start to age out until 2017. Statute of limitations goes far beyond that. So I want to take a look at it to kind of see how it's reporting before you waste an attorney's time with that. So I'll put instructions in the chat for you. Thank you again. It's a good question. All right, let's take a look at this joint real quick here.
Remove.
Okay. No explanation so far of anything.
Bye, man. You know what else? Let me show y'all this thing work. Let me show you. So, after submitting that letter to the debt collector, right, with certified mail,
Jesus Christ,
right, I then submitted a complaint to the CFPB, and I gave them that tracking number. I did ask for compensation because they were violating, but they said, per your concerns and requests, for no further calls, the above referenced accounts have been marked cease and desist. While accounts remain due, and only we will no longer contact you by phone or mail unless required by law. Bow!
Okay, so at this point, I'm starting to realize that these people are just going to put any kind of USC code up on the screen and say whatever.
Yeah. So let me show you. So the subsection about the cease and desist is not 1692 D. It's 1692 C, and it's 1692 CC. And let me, if I can. So I'll first show you D, which here we go. So 15 USC 1692 D, just harassment or abuse. And this is a catch-all provision, the top portion of it. So it means that any of this stuff falls under 692D, but it's not limited to all of the things that are mentioned in the numbers. A debt collector may not engage in any conduct, the natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of a debt. Without limiting the general application of the foregoing, the following conduct is a violation, which is the threat of use of violence, the use of obscene or profane language, a publication of lists of consumers who refuse to pay debts, the advertising of sale of a debt, causing the telephone to ring, engage repeatedly or continuously to annoy, and then placing of telephone calls without the meaningful disclosure of the caller's identity. If he's talking about 1692C, about the cease and desist, the communication in connection with the debt collection, this is subsection C, ceasing communication. And this is where 1692CC comes in, where you ask the consumer, if a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or the consumer wishes that the debt collector cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to a debt, except to advise the consumer that the debt collector's efforts are being terminated. So that's what was happening in this section, where the video where the guy where they told the consumer that we are not going to contact you anymore, and the cease and desist is valid. To notify the consumer that the debt collector or creditor may invoke specific remedies. That's usually when they tell you, okay, we're not going to contact you, but we can still sue you for it. And where applicable, to notify the consumer that the debt collector or creditor intends to invoke a specific remedy. If that they tell you they're going to sue you, they can tell you that they're going to sue you because you told them to not contact you. If such notice of the consumer is by mail, notification shall be complete upon receipt. So only when the creditor gets it, or the debt collector, or in this case the debt collector, because it's the FDCPA, if the debt collector gets the letter, it's only good upon receipt, if you've told them not to contact you anymore.
Cool, man. All right. So you guys, we just about run out of time. Now that I know exactly how to run my crap, we'll do this with Subhan again. I'll have a bunch of videos loaded up for him so that he can continue to give us his opinion on what's actually going on with consumer law in regards to credit repair. Subhan, I appreciate your time today, my man, and I appreciate everybody who joined this live. It's been about an hour, almost an hour and 15 minutes. I got to go grab my little nuggets from school and get this daddy daycare rolling. Subhan, did you have any other stuff you want to put out there, man, before we get out of here?
So if anyone has, first of all, like our Facebook and YouTube and all that stuff. So
hit that like for the algorithm.
There you go. And you can contact us if you go to tariqlaw.com, TARIQLAW.com. It's kind of on the shirt here. Like, subscribe, and share, and hopefully we'll be back soon.
Listen, if you guys want me to do this again, I know this is boring for a lot of you, but I love it. I absolutely love this, and I can't wait to sit down with Subhan for about 20 straight hours over the next, well, not 20 straight hours, but about 20 hours over a weekend, man, and do nothing but let him flood my brain with this information so I can continue to bring it back to you guys. Other than that, man, I do this for you guys, man. I continue to pour everything I can into my platform so that you guys cannot be feloniously had by these, let's just call it what it is, these straight up scamming ass, raggedy ass scammers out here. And I'll continue giving you guys what I got, man. I appreciate you guys. I know you guys can go anywhere to get your credit information, but you stay here with me. Appreciate y'all.
Take care, everyone.